Buenos días y bienvenidos a nuestro webinar sobre la nueva ley alemana de cadena de suministro y su impacto en España. A special and warm welcome to our friends from Gleiss Lutz, Mark Rudloff and Eric Wagner, which are renowned experts in this field. And thank you for joining and sharing your insights and your experience on this matter. We are talking about the German Supply Chain Act, which in German has the cozy and easygoing name Lieferketten-Sorgfaltspflichtengesetz. So I had received some questions, so no issues on that. No German language skills are required today. So we have agreed with our friends to do this both in English and in Spanish. So in fact, Elisabeth and myself will kick off in Spanish, and then we'll switch to English with presentations from Mark and Eric. Pues la primera pregunta que os habéis hecho, muchos de vosotros, es ¿por qué Cuatro Casas habla de una ley alemana? La segunda, ¿y qué nos importa esto en España? Pues a la vista está que la mayoría de vosotros se ha podido contestar esta pregunta. Tenemos más que 200 asistentes en este webinar y parece que ha suscitado interés esta ley, como hemos comprobado en las últimas semanas. Luego lo comentaremos con más detalle, pero es obvio que esta ley alemana tiene un impacto en España y para empresas españolas, los que hacen negocios con Alemania y no necesariamente tengan presencia propia mediante una filial o otra forma en Alemania. Esta normativa sobre la ley de cadena de suministro se marca dentro del megatema ESG o ESG, que está omnipresente en todos los ámbitos y también en el mundo jurídico. Pues muchos de nosotros lo vemos en el mundo M&A, en el mundo corporate governance, en financiaciones, en todas partes. Ya, somos conscientes de este auge de ESG, obviamente, en Cuatro Casas, y como siempre, pues estamos al día de las novedades y los desarrollos, y hemos organizado una unidad, un departamento de ESG, que justamente está dirigiendo mi socia Elisabeth de Nadal, que saludo aquí también, Elisabeth. Y Elisabeth os va a enmarcar ahora un poco esa ley de cadena de suministros alemana, en el contexto general del ESG, ¿vale? Antes de esto, solamente pues recordaros, aquí tenéis abajo en la pantalla, en el botón Q&A, podéis hacer vuestras preguntas, espero que sean numerosas. En cualquier momento los vemos los ponentes y los vamos introduciendo o inmediatamente, si son realmente pues, urgentes, o al final. La idea es que tengamos al final 10-15 minutos un coloquio donde podemos contestar y comentar todas vuestras preguntas. Elisabeth, adelante.
Gracias, Kai. Welcome, Eric and Mark. Pleasure to have you with us. Buenos días a todos. Esta sesión nos da una oportunidad de ver y de sentir y de comprender los efectos prácticos en la operativa de las empresas de la gestión ESG. Es decir, un poco bajar del mundo de las políticas y las declaraciones ESG a las obligaciones jurídicas que afectan al tráfico jurídico y a los estándares de conducta de la empresa en los mercados. ¿Por qué las cadenas de suministro inciden en los derechos humanos y el medio ambiente? Bueno, la respuesta es bastante obvia, ¿no? En un mercado global, las empresas nos suministramos, nuestras cadenas de suministro se extienden a través de distintos países del mundo, no solamente dentro de nuestras fronteras. Y cuando estas cadenas o en estas cadenas se producen o hay riesgo de que se produzcan violaciones de estándares internacionales en materia de derechos humanos y de protección del medio ambiente, han sido hasta hoy objeto de crítica por la sociedad civil y por las organizaciones civiles, pero además hoy, y hoy lo veremos con esta nueva ley de nuestros vecinos alemanes, son objeto de nuevas regulaciones que lo que pretenden es evitar que, como efecto de la globalización de la economía, se produzcan ámbitos o limbos que de alguna manera permitan a las empresas aprovecharse o no vigilar adecuadamente aquellos contextos jurídicos más débiles o regulaciones domésticas más deficientes, esquivando así los estándares de protección internacionalmente admitidos de los derechos de las personas y de los efectos dañinos en el medio ambiente de la actividad económica, ya sea en nuestro propio país o ya sea en otros países. Para comprender un poco la magnitud de esto, os doy algunos y el por qué está saliendo regulación de estos estándares de conducta en las cadenas de suministro. Os doy unos datos muy breves. En la Unión Europea, apenas un 35% de las empresas realizan procesos de vigilancia de los efectos de los derechos humanos en la cadena de suministro. Solamente un 16% realizan una due diligence completa o dicen que realizan una due diligence completa de la cadena de suministro. Y en cambio, conforme a las últimas estadísticas del 2020 de la Organización Internacional del Trabajo, hay cada año a 25 millones de personas víctimas de trabajos forzados, 152 millones víctimas de trabajo infantil, 2,8 millones de muertes al año por enfermedades laborales o accidentes laborales y 374 millones de accidentes laborales al año, ¿vale? Del mismo modo, el daño ambiental, ya sea local o global, resultante de la actividad empresarial, viene a justificar que se empiecen a diseñar estos estándares de conducta para las empresas. Es en este contexto que Alemania se ha unido a otros países de la Unión Europea, lanzando una nueva ley sobre debida diligencia en la cadena de suministro. Esto confirma dos cosas. Uno, una tendencia que está liderando la Unión Europea del tránsito de la regulación de estos estándares de conductas a través de normas y códigos de conducta voluntarios, de autorregulación de las empresas, hacia la inclusión o la creación de nuevas obligaciones legales. Esto lo ha hecho Alemania, lo hizo también Francia hace unos años, en el 2017, con su ley de vigilancia. Lo ha hecho también Noruega y Austria, que tienen también sus propias leyes, y existen en este momento iniciativas legislativas similares en Bélgica, en Suiza, en Holanda, y también España ha anunciado una norma de esta naturaleza en su plan anual normativo para este año, para el 2022. No todas las normas de los países europeos son iguales. Hoy hablaremos de la alemana, y todos estamos esperando también la iniciativa de una directiva comunitaria que está en la mesa de la Comisión de la Unión Europea, que se esperaba para finales del 21 y ahora parece que la están anunciando para el primer trimestre de este año, que va a dar una cierta armonización en estas distintas iniciativas que cada Estado miembro de la Unión está adoptando. ¿Cuál es, muy brevemente, el enfoque de la nueva ley alemana? ¿En qué se distingue de otros enfoques de otros países vecinos? La ley alemana tiene un enfoque regulatorio administrativo. Más que desde la legislación civil, introduce una obligación regulatoria que conlleva el cumplimiento de un nuevo estándar de diligencia, de prevención, mitigación y remedio, que está controlada, esta prevención, por parte de la administración pública y expone a la empresa principalmente a sanciones públicas, aunque también, como nos contarán Mark y Eric, a riesgos de litigación. La obligación la pone de forma progresiva, empezando para la gran empresa, pero en unos años bajando esa obligación a empresas de mediano tamaño. Y lo que conlleva es la obligación de realizar un análisis de riesgos, de afectación en la propia operativa y en la primer eslabón de la cadena de suministradores directos, de potenciales impactos de derechos humanos y medio ambiente. Y aquí incluye, como veremos, desde el trabajo infantil al trabajo forzado, a las condiciones de seguridad y salud, a las condiciones de trabajo dignas, incluido el salario, al derecho de sindicación de asociación, la discriminación por razón de sexo u otras, vida, derecho de vida, apropiación indebida de tierras, etcétera, etcétera. Esta obligación solo se extiende, como veremos, más allá del primer eslabón de la cadena cuando hay un conocimiento sustancial de un potencial abuso o violación. ¿Por qué nos tiene que importar? ¿Por qué debemos estar alerta como empresas españolas? ¿Qué me importa a mí si estoy en España? Primero, porque como veremos y como haya avanzado Kai, la ley alemana afecta a todas las empresas españolas que tengan filiales que cumplan el tamaño a las que se les va a aplicar filiales alemanas operando en el mercado alemán, ¿vale? También si son filiales de empresas alemanas que se encuentran obligadas por su ley doméstica, pero también afectará a todos aquellos que seamos commercial suppliers, partners comerciales, proveedores de una compañía alemana obligada por esta ley. Por lo tanto, los compliance committees de las empresas españolas, pero también los directores comerciales, los CEOs y los consejos de administración tienen que estar atentos a estos estándares de conducta y de vigilancia, tanto de sus propias operaciones como de sus partners comerciales, no solo porque ahora la ley alemana nos lo pone mucho más cerca, sino también teniendo en cuenta que este tipo de estándares ya se están introduciendo en la normativa española de divulgación de información de ESG y de rendición de cuentas, ¿no? En el EINF, con la nueva directiva que refuerza esa obligación de rendir cuentas sobre la gestión no financiera de la actividad comercial. Por lo tanto, con esta introducción, I pass the word to Eric and Mark so that we can learn with more detail about the insights of this new German Act.
Yeah, thank you, Elisabeth, and thank you, Kai, also for having us. We are delighted to give you a short overview on a new legislative act in Germany, the so-called Act on Corporate Due Diligence Obligations and Supply Chains, and in other words, the Supply Chain Due Diligence Act. It is one of the most important legislative acts in the last couple of years here in Germany, and it will have a very broad and significant impact on German companies and on companies sitting abroad doing business with German companies. So if you look at what we have with regard to laws in this specific field to date, when it comes to protecting human rights, when it comes to protecting environmental goods, we have more or less only reporting obligations here in Germany, reporting obligations that aim on big companies seated here in Germany, which have to provide certain information in their annual reportings about measures they have taken in order to protect human rights, in order to protect environmental goods. However, no specific level of due diligence and care, so what kind of measures specifically they have to apply, is defined in these kind of laws we have today in Germany. In addition to that, we have some very narrow legal fields in which we have some limited obligations to make certain efforts to protect human rights or sustainability goals. But as I said, these are very narrow and specific fields of law. And beyond that, we only have some voluntary standards that come into play in certain sectors, like, for example, the textile industry. I'm sure you're very well aware of this in Spain as well. But as I said, these are voluntary standards, yeah. So you do not have necessarily to apply to comply with these standards. And with this new legislation now, the whole situation changes, because now, independent of the sector in which you are in and independent of the product you're putting on the market, a very high level of due diligence and care will have to be applied in the supply chain. And what we would like to describe today, outline today, is what kind of obligations are in it, who will be affected directly and indirectly of the new legislation, and what things can be done in order to make the necessary preventive measures, preventive actions to prepare for the implementation of this law. When you look at these obligations coming out of the law, it's always helpful to also look at the lawmaking process. And in this particular case, there are some particularities in this regard, because even though it was the aim of our former government to implement such a law, work on it started very late, and it was then only a 6-month period between the first presentation of a draft and the passing of the bill. And during the 6-month period, it was discussed very intensively and controversially. And a lot of changes have been implemented in this law at a very late stage. This, in consequence, led to a situation where we have now a very high standard that is put forward in the law, and a lot of obligations that are in it. Also, a lot of sanctions that are included in the law, but a lot of questions remained open, and a lot of vaguenesses and a lot of room for interpretation is in the law. So this makes it tricky and difficult for everyone to deal with it. Still, it has become reality, so we have to deal with it. And in order to understand better what we will now outline on the next couple of slides, is that the key characteristic of the law is that governmental tasks are shifted to the private sector. So tasks like surveillance and ensuring the implementation of certain diligences with regard to the protection of environmental or human rights goods will be shifted to the private sector, so more specific to the big companies at the end of supply chains. They will be directly addressed by the law, and now they have to implement their obligations and comply with their obligations by implementing certain provisions in their contractual arrangement with their suppliers, and request from their suppliers to implement measures in their agreements with suppliers that are tier 2 and above, so no direct suppliers but indirect suppliers. So even though the law defines obligations directly only for the really big companies here in Germany, it relates to their business relationships, and this is why it becomes so important to be aware of these things also as a company doing business with German entities, because you will see that a lot of these obligations will be put forward to you, and you have to comply with these obligations. Otherwise, you will no longer be able to do business with the big companies. We go to the next page, please. On this page, we have described the scope of obligation. So, in other words, by when should the preventive measures be in place? And there are 2 points in time you have to watch out for. The law will enter into force on the 1st of January 2023, so beginning of next year. And as I said, so the direct scope of application is aims on big German companies. So 2 requirements must be met in parallel. The first requirement is that the company must have at least 3,000 employees in Germany. However, when it comes to group structures, you have to keep in mind that not only the employees at a certain company will be taken into account, but you have to look at the whole group of companies. And if you have, for example, a parent company with, let's say, 1,000 employees, and you have an affiliate, a daughter company with 2,000 or more employees, then the 2,000 employees from the daughter company, from the affiliate, will be added to the 1,000 employees on the level of the parent company. So the parent company will have 3,000 employees and therefore meet the threshold, here the first threshold, which will apply as of 1st of January 2023. So even though the own employees will only be 1,000, the parent company will have to comply with the obligations out of this law, because the 2,000 other employees out of the affiliate and the group companies will be added to the 1,000 at themselves. In addition to that, the central administration or the principal place of business or a domestic branch office or a statutory seat in Germany is necessary. So if either of these is present and the threshold with regard to the employees is met, then such a company will be direct subject to the obligations under the new legislation. And if you look at the right side of the slide here, starting from the 1st of January 2024, so 1 year later, the threshold of 3,000 employees will be reduced to only 1,000 employees. And this means that, much more companies than at the very beginning will be directly affected by the law. What we have put here in the right bottom is all in the right box is that companies with fewer employees will be affected indirectly. We will come to that in a minute, because as I said, so these obligations aim on the big companies, but now they are obliged to fulfill certain due diligence standards with regard to their tier 1 suppliers and all the beyond. So if you are a tier 1 supplier, or if you are a smaller entity doing business in Germany, then if you have in your customer base all the companies that meet the threshold and the requirements as set out on the slide here, you will most likely be confronted with the requirements under these legislative act very shortly. On the bottom of this page, we have also given some information on the current development on the European level. There was a suggestion that large enterprises shall be affected by a similar legislation like the German law here, and the large enterprises shall be companies which have at least 250 employees, so a much lower threshold again than the 1,000 you have seen a minute ago. Or, so in the alternative, an annual turnover of more than 50 million euros, or a balance sheet of a total of more than 43 million euros. So you see, now we are speaking about really small companies, not only the really big ones, but really medium-sized and smaller companies. And in addition to that, for certain high-risk small and medium-sized enterprises, so without applying any thresholds in this regard, when it comes to employees or a balance sheet and so on. So if they face a very high risk, like in certain sectors, this might be the case, like the textile industry, for example, then the new legislation on the European level shall apply on these enterprises in any case. However, it's not yet really a formal proposal, and is not yet law. So it was announced that at the 8th of December, a specific proposal will be presented, but then it was retracted, and so now we expect a proposal around March, April this year, and we will see what's in it. You couldn't go to the next slide, please, Kai. You're on mute, Mark.
And if we take a closer look at the individual and collective interests protected by the Act, then we can see that there's an emphasis put on human rights, and not so much on sustainability, environmental obligations. And this is, can be easily explained by the history of the draft bill. So the first drafts were mainly based on the protection of human rights issues. And just later in the legislative procedure, also sustainability and environmental obligations were added. And some of them even came into the draft bill quite at the end of the legislative procedure. And that's why the human rights are more in the focus than the environmental issues and objects. And the whole structure of the law is mainly to refer to international treaties such as the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Core Convention of International Labor Organization, and so on. So it's a kind of dynamic reference, and it can be easily amended in the near future. So the whole structure of the law is mainly based on this reference to these international treaties. And what we tried here in this slide is to give an overview of the main objects protected by the law, which can be regarded as different groups of objects and protected issues. And the first one is the protection of certain groups of persons, especially the prohibition of child labor. So on the one hand, for children below 15 years and below 18 years when it comes to special kinds of work which are more dangerous than others. Then the prohibition of discrimination based on gender, ethnicity, religion, or different kinds of objects, and so discrimination is also one of the main issues. And as you already may know from the public reports, especially when it comes to China, this is one of the main issues which is to be addressed by the lawmakers, and it's also a kind of let's say a weakness of political power, that they were not able to address these issues so far, but now it's a kind of shifting these obligations to the companies and try to put some pressure on this international level, which has not been done by the political class so far. And another group of protected objects are aiming on, let's say, occupational health and safety. It's on the one hand prohibition of slavery and forced work, but also things like freedom of association, minimum standards regarding occupational health and safety, and appropriate wages, minimum wages. And this is a good example to explain how difficult it can be for companies to address these issues, because these international treaties are aiming on appropriate wages, which is easy to assess insofar as in a lot of jurisdictions there are legal frameworks set up defining kind of minimum wages. But there are also jurisdictions where none of these legal frameworks are set up, and then it's still up to the companies to assess if appropriate wages are addressed by their suppliers, and that can be quite difficult. And that is just an example to highlight and to explain what difficulties may come up in the near future, because these international treaties are often quite general, and their approach is quite open and has still be precised by the legislator on a national level, or at least by different guidelines, and that is not always easy to have a reference in the different jurisdictions. And the last group of objects are aiming on sustainability and environmental obligations. So one of these main examples is the prohibition of land grabbing and the deprivation of livelihood, and the prohibition of pollution and the use of certain chemicals. One of the main chemicals is mercury in this regard, which is especially of relevance when it comes to mining and these kind of industries where mercury is used. And finally, and that is one of the latest objections which has been added to the law is the prohibition of export of hazardous waste. So it's the Basel Convention, which is has been made reference to in the legal framework. So this is just to highlight the main aspects of the law and to give you a short impression what is protected by the law. And Kai, if you would like, please skip to the next slide, where we have a kind of an overview what different layers of the supply chain are addressed by the law. And as Eric already mentioned, the main obligations address directly the tier 0, let's call it like this, the tier 0 companies. These are the larger German firms, as defined by Eric before. But this can also be a trigger for Spanish affiliates to be indirectly, or indirectly, it's the wrong phrase, but to be also somehow addressed by the German law. Because the law also says if there is a decisive influence on affiliates, even if they are based abroad, then the German parent companies is obliged to fulfill the obligation also with regards to the business area of the foreign affiliate company. So to explain that more with a picture, so the whole business area of the German parent company and the affiliate companies are regarded as one whole business area, and the parent company is obliged to fulfill all the obligations and to use their decisive influence to make sure that all these obligations set up by the German law are also be complied with within the business areas of the affiliated companies. And it makes not a huge difference if these affiliates are located in Germany or somewhere abroad, just as long as these decisive influence is in place. So that is definitely one point to keep in mind from perspective of Spanish affiliate companies bound to a German parent company. And a huge part of their obligation is, of course, to make sure that all the obligations are fulfilled in their own business area, but also to pass along these obligations to their direct suppliers, where there's a direct contractual connection in place. The law has the idea that the tier 0 companies have at least the power to adapt their contractual basis and to pass along all these obligations to the direct suppliers and to ask them for audits and for information, and to make sure that the same same protected objects are in their focus, and that they also set up a kind of compliance structure. And even the suppliers on the tier 2 and above level are addressed to a certain extent by the lawmakers, and at least on these levels, also Spanish companies being suppliers of German companies may be addressed on the one way or the other with these obligations set up by the Supply Chain Due Diligence Act in place and implemented in Germany, as the tier 0 customers will be obliged to pass along these obligations to their suppliers wherever they are located in the world. And so on the next slide, please skip Kai. We will try to give a kind of an overview what kind of preventive measures related to the German companies and their tier 1 suppliers have to be set up, and what has to be done by the German companies, and what kind of obligations may be passed along through the contractual structures. And the whole preventive measures can be regarded somehow like a pyramid, and that's how we try to make it more obvious what has to be done. And the basis of all of this is the documentation and reporting that has to be done by the companies, directly addressed by the Supply Chain Due Diligence Act. So these companies are subject to an internal documentation obligation and an external reporting obligation. And the purpose of such due diligence obligations is in general to enable also the competent authorities to monitor the compliance with the provisions of the Supply Chain Act, but also to ensure that there's more transparency in this regard. And the first thing is that the companies are obliged to issue a declaration of principles which defines the corporate human rights strategy. This is a kind of, let's say, main paper outlining the strategy as a whole. And they are also obliged to, in addition to document internally whether and how they fulfill their due diligence obligations, how they try to implement their human rights strategy. And this is also accompanied by an obligation to retain the relevant documentation for a period of at least 7 years. And finally, these reports must be published on an annual basis and published on the company's website, and also to be provided to the competent authority. So this reporting obligations are really something that leads to transparency in this regard, and it's an obligation that is kind of the basis of these whole preventive measures. And based on that, the companies have to implement an appropriate risk management and risk analysis process in their business operation. This means they have to conduct a risk analysis to determine which measures they have to take in order to ensure their compliance with the prohibitions set up by the Supply Chain Due Diligence Act. And such risk analysis has to be carried out not only once, but regularly on an annual basis, but also when it's appropriate. So, for example, if different or additional information comes up in the event of the occurrence of events on an international basis, which could lead to a different assessment and may raise additional risks, then this risk analysis as a whole has to be carried out again to assess if different measures have to be implemented. And this risk analysis and the risk management system are let's say the compliance structure to be set up and to be prepared to evaluate and to prioritize where or which companies in the supply chain have larger risks and which ones have minor risk, and just to be able to select where more measures have to be implemented, and what companies in the supply chain are not do not bear so many risks in their setup. And based on that, preventive and remedial measures have to be implemented once a risk have been detected. The companies have to prepare, especially legal framework, and to set up legally or contractually implemented instruments to be able to force their suppliers to take care of eventual upcoming risk. This also includes the obligation to take part in training courses, to have a supplier monitoring in place along the supply chain, to provide additional material, to explain what preventive measures are carried out, and so on. And as a kind of an ultima ratio measure, also there may be an obligation at the end, if all other measures do not work, to terminate a business relationship if there are hints that it just does not change anything in the area of one supplier, and if there are especially proof for ongoing infringements of the standards. So this is kind of a brief overview of the obligations that have to be set up within the companies directly addressed by the law. And so please skip to the next slide, and then it's up to you, Eric, to take over again.
Yeah, I mean, a lot of the obligations you have just mentioned are obligations you will see in contractual arrangement. This is, in fact, what we see in our daily practice now as well. A lot of clients already started to implement the obligations and now to implement them in their supply agreements, in particular these long-term agreements going beyond the 1st of January 2023. And for example, implement certain supplier standards, include certain provisions for an audit of the suppliers and monitoring and so on. When it comes to tier 2 and higher, so now we have spoken about the tier 1 suppliers. When we speak about the tier 2 suppliers and higher, at first glance you can think that the level of obligation is rather low in this regard, because the law only speaks about documenting and reporting obligations. So you have to include tier 2 and above also in your documentation, have to show what kind of measures you have taken in order to get rid of certain risks, for example. And in addition to that, you have to set up a complaints procedure, which is also accessible for tier 2 and higher. So a very low level of diligence compared to what Mark has described before with regard to the tier 1 suppliers. However, in the event of a substantiated knowledge, so meaning you have actual indications suggesting that a possible violation of human rights related or environmental related obligations are in place, then the threshold, the level really increases from one moment to the other. Then all the obligations you have seen on the slide before come also into place with regard to tier 2 suppliers and higher. So you have to do a risk analysis, you have to implement preventive measures, you have to implement a remedial action plan if a violation has already been committed. And this you can only do if you have contractual provisions in place from the very beginning, because you do not know at which of your suppliers and indirect suppliers such problems will occur. So you have to think about implementing certain provisions in the contractual agreements with your direct suppliers, giving you a basis for going to your direct supplier and say, well, we got knowledge about a problem with your sub-supplier, so please take care of it, ensure that it will be eliminated, the risk, and provide us with an update on this, look into what has happened exactly, and so on. So you need the contractual arrangements also with regard to the tier 2 suppliers and higher. This is why the obligations go even beyond that, what Mark described before, and you have to implement even more provisions in the agreements with your direct suppliers than dealing only with their specific level. If you can go to the next page, please, Kai. So here only some few words that the regulatory concept is a best efforts obligation concept, meaning that it's not outcome oriented. It's not relevant whether there was a violation or not. It's only whether you have implemented the necessary level of diligence and care. So even if there was no violation, but you have not implemented the necessary level, then yeah, a breach is present, and we come to the sanctions and the civil liability in a moment. Then all these negative consequences can hit you. And so it's very important that you really try to fulfill this best effort standard as a company that is directly affected, and implement this standard also with regard to your suppliers. So then the indirect affection of the other companies will come into play. And if you look at now what means best efforts, yeah, it's of course something which is possible at all, yeah, individual possible in the individual case, and reasonable. The term reasonable is used very, very often in the law, 19 times in total. And since we have no specifications by administrative authorities or by court decisions, our suggestion at this stage is that if you set up a process which shall fulfill the best effort standard, try to check in with external legal counsel, because they have kind of a external view on it. And in the end, when administrative body or court comes to the conclusion, well, you have not done what you can be expected to do, then it's much easier for you to defend yourself, because you can relatively easily show that that was not due to internal discussions or maybe cost-saving reasons or something the like, but you have included external legal advice, and what could you do more than that in order to set up an appropriate system if the lawmaker does not provide more details on that. That's, I think, in essence, what's in the law. And now we have 2 or 3 more slides where we show some of the sanctions and consequences, but I think we can keep this rather short because the presentation, the slide itself, it's more or less self-explanatory. Mark, if you would like to start with the public consequences that can follow.
Yeah, and this is important to understand that there is some pressure by the authorities which can be expected. For example, the draft bill has also already set up that 65 additional full-time equivalents will be responsible in a new department of the competent authorities. And the BAFA, the competent authority, is responsible not only to publish some handouts and guidelines, which we do not expect to be very precise at the beginning, but also is in charge to monitor the compliance, and they have a quite far-reaching set of competences. And they can ask for additional information. They have access rights. They can order concrete preventive and remedial measures. So there will definitely be a monitoring process being set up in the near future. And we definitely are sure that these 65 full-time equivalents will just be the beginning. But if you please skip to the next slide. Which is even more interesting is that these powers of the authorities are also addressing sanctions, and they have additional powers to investigate potential regulatory offenses, and the fines are quite significant. So depending on the offense, the maximum fines are ranging from 100,000 to 800,000 for individuals. And there's a factor 10 for companies, so it's up to 8 million for companies. And in addition, there is a fine which can be set up is of 2% of average annual worldwide turnovers. So these are really significant fines, because all companies operating as an economic unit are regarded as a whole, and this is the reference made for the turnover. 2% of it can be the maximum fine to be implemented, and which is also of importance for some companies. A consequence can also be to be excluded from awards of contracts, which means public contracts, for a period up to 3 years. So in some areas, in business areas, it's quite important to have the public entities as customers as well. And for these business areas, this is definitely an additional quite important consequence, which may come up as a result of an infringement. So, and then I would like to hand over to Eric again when it comes to the civil law sanctions as a potential.
Go on the next page. Perfect. I mean, what as Mark mentioned right now is something which will have a detrimental effect on your financial situation if you are directly affected by the law. And of course, now you can bring recourse claims against your suppliers under German law if your supplier in fact has given rise to the sanctioning, because the implementation of the diligence and care was not done in a proper way. It's worth mentioning that liability under the law remains unaffected by the statement that the provisions under this agreement shall not form protective provisions. So not every breach against such a provision shall directly lead to a damage claim. However, you can of course bring tort claims. You can of course bring contractual claims forward against the companies directly addressed by the law, or by way of recourse claims, then also by against companies who are in the supply chain and who make business with such directly affected companies. So a lot of litigation in this regard is to be expected, in particular given that the whole framework for claims and litigation in Germany has changed over the last couple of years, and it has become much more contentious than it was before. Yeah, on the final page, Kai, if you can skip one slide again. On the final page, we have put together some recommendations what you should do, irrespective whether you are directly or indirectly subject to the act, and what can be done in order to prepare for the act coming into force. It should be done right now because, as I said before, we already see that a lot of our clients have implemented or start implementing these obligations. So if you do business with a German entity which is directly subject to the law, it might well be that in the next couple of weeks or months you will already be confronted with the obligation and the standards of this law. In particular, if you are concluding long-term agreements going beyond the 1st of January 2023. And in this regard, it definitely makes sense not to react to such demands of your customers, but to implement their own structure and their own level of diligence in your own sphere and also along your supply chain, which you can then show to your customers and can say, well, this is what we can offer you. And so you do not have to react to certain different demands from different customers, but you have a system in place which complies with the German Supply Chain Act here, and is constructed in a way that it works with all of your customers. So this is definitely something which will help you not to have any interruptions in your business process. And yeah, some of the specifics about that we have outlined here, but this is of course only a starting point, and you have to go into the details to set up a proper structure. Yeah, that is all from our side. Thank you very much, and we're of course happy to answer any questions you might have.
Yeah, thank you very much, Eric and Mark. This was very insightful. We have certain interesting questions in the Q&A. So maybe take it from here. The first one I would like to share with the audience is, I guess this is a Spanish group, and the question is, in terms of the scope of the counting of the 3,000 employees, what happens if there's a German subsidiary, which is smaller, I guess, than 3,000, but the parent company, the Spanish parent company, is bigger, and there are other affiliates in other countries. Would all these employees which are not in Germany also be accounted for these purposes?
No, only the German employees will be accounted.
Okay, very good. So this is, I think, then this is a kind of relief for this
we hope so.
person. Okay, very good.
I'm afraid it's a momentary relief, because when we have the EU directive, the thresholds are much lower. So
indeed.
Yeah. Then another interesting question is somehow related to, guys, we already have a lot of, let's say, policies and preventive measures in our groups, in our companies, in compliance, in ethics codes, and so on and so forth. Do we now really need to put this in a different way, in a different format, and different structures, or can we somehow, use these already or existing ones?
I think this could be used as a basis. So we did in the past in several other cases with several of our clients. But our experience shows that given the really broad and depth of the obligations now formulated by the new legislation, you usually have to revise it and, honestly speaking, heavily revise it in most cases we have dealt with so far. Not only with regard to the supplier codex and the supplier standard, but also with regard to implementing certain contractual obligations, like audit rights, like remedial plan, with certain deadlines, the right to terminate the agreement if such violations are not excluded, and so on. So a lot of additional provisions and standards will most likely be necessary without having seen now, of course, your specific standards and documents you're dealing with to date.
And this is mainly what is meant by the term gap analysis mentioned in our slide. This is what we have done before for many of our clients, because the situation is often similar, that there are already structures in place, but to start with, is to analyze what kind of obligations are already addressed, and are all kinds of objects be addressed. So not only human rights, but also environmental objects. And so the starting of the gap analysis is to see what is already in place, where are the gaps when you compare that with your legal obligations, and then to set up a plan what already has to be done to improve the existing compliance structure.
Mm-hmm. Thank you. Another question here refers to, let's say, more on organizational matter, which is something that several, let's say, German clients asked me already. I guess this is from a Spanish subsidiary of a German group. The question is very simple. Where in the company will this issue be dealt with? Means in the legal department, in the compliance department, or will there be new ESG or supply chain departments? What's your experience on that when it comes to when you're speaking to your the big German corporations on these topics?
It's the short answer is we have seen that in either way. So there is not one correct way to do it, but the main thing is to do it in an effective way. So the threshold is the effectiveness, but there's not the one way you have to go, but to try to have an effective structure in place. And if this means to set up a different department, then that's the way to go. But you can also use existing departments to carry out all these obligations. So It depends. It's often the answer of lawyers.
Yes, if I may, I think that independently on whether you appoint either the compliance area or a specific ESG or human rights area inside your company to do the process to identify the risks and put in place the measures to prevent that risk materializes, your legal department probably would like to be involved, because probably you will need to transfer some part of this risk analysis to your supply contracts.
That is definitely true, but we have seen companies having a legal department, a CSR compliance department, a normal compliance department, and a new ESG and supply chain department, having a lot of structures in parallel, and others just have kind of sub-departments of their legal department to be in charge of that. Just would like to point out that there are different solutions and different ways to answer that question. That's definitely to be decided on a case-to-case basis.
And maybe one additional comment to that. I mean, you always have to look out for spillover effects. For example, when it comes to money laundering directive, you might have implemented already certain level of due diligence. And so now if you have implemented something in this regard, it should fit to what you implement in this regard. I mean, the level should be quite comparable, because if you implement in one direction a much higher standard than in the other direction, this could give rise to a point of attack to say, well, in this regard, you was able to do much more, so why didn't you do it also in this regard? So this is why a central function should be implemented, which really has a total overview on what kind of compliance and diligence systems are implemented in the company and what level is achieved in this regard.
Very good. Then there's a really interesting question which affects us as well. The question is whether supply, what's the definition of supply in this sense? Is this only that, let's say, what we imagine machinery and car parts, or is it also it's also containing, let's say, services, for instance, from lawyers, banks, or other service providers?
Right. So service providers are covered by this term as well.
Okay, so we are in.
We are in, definitely. Yeah.
Okay.
Not as well, but to also add some thoughts on this, it's not about I don't know, some fruits and vegetables you offer to your employees. That's where it ends. But there's a certain connection to your main business. That is more or less the test you have to execute.
Mm-hmm. And then I think you already, let's say, addressed this shortly in the presentation, but the question is a very concrete one for a Spanish supplier. What is your recommendation? What should he do in this year 2022? And what is the expectation? What will come up? What will arise? Which kind of approaches will be made from the German customers?
I mean, this is what Mark said. The first step, I think, is the gap analysis to see what kind of obligations will hit this supplier. So I assume it will only be an indirect affection, not a direct one, but that has to be checked, of course. If it is an indirect one, I think it should be checked whether there are already certain standards established internally and along the own supply chain, like own supplier standards, code of conduct and such stuff, which will comply with the obligations out of the new legislation. If not, we definitely recommend to use the time until 1st of January 2023 to sharpen these kind of standards used internally and with their own suppliers, and set up a compliance structure internally as well, which will be sufficient to offer the big customers, which will then be directly affected by the law, kind of a solution, kind of comfort to say, well, we are well aware of this development. We have already a structure in place which will help you to fulfill your obligations under the new legislation.
Mm-hmm. Okay, and then there's a question for Elisabeth. So the question is, will the Spanish law, upcoming Spanish law, and with the Spanish law, will it be similar to the German one? Will it be different? What is the expectation? What we'll have to face here in Spain?
There is still, bueno, esas, me paso al castellano si queréis. Sí. O, sí. No hay, lo único que tenemos hasta ahora es la inclusión del anuncio de esta normativa en, como os he dicho, el plan anual normativo del 2022. Es verdad que es un plan anual muy cargado de nuevas normas, ya veremos hasta dónde llega el Gobierno y el Parlamento en la elaboración de todas ellas. Viene del Ministerio de Asuntos Sociales y está copropuesta también por el Ministerio de Consumo, con lo cual, bueno, es una pura intuición, no tiene ningún tipo de certeza porque no hay un borrador ni un proyecto ni se ha lanzado más información, pero yo creo que igual tiene un enfoque más desde la perspectiva civil y no tanto administrativa regulatoria, sin perjuicio de que se planteen el control y sanciones públicas, ¿no? Por así decirlo. Lo que yo creo que va a pasar es que se va a solapar con la directiva comunitaria, ¿no? Y en el momento en que haya una directiva europea que dé un plazo de transposición, eso inmediatamente va a todos aquellos países que estamos en fase de diseño de estas normas, nos va a influenciar, ¿no? Y vamos a tener que cumplir ese marco mínimo armonizado que esté dictado por la directiva.
Uh-huh. Y hay otra pregunta aquí que se refiere a una empresa española que exporta productos a Alemania, y la pregunta es si existe la obligación de diseñar un código de conducta o vigilancia. Si es así, el Consejo de Administración de esa sociedad debe estar anualmente informado al respecto. Bueno, Elisabeth, eso también es para ti.
Claro, yo creo que igual no entra en el efecto, ¿no? Como parte del efecto directo de esta norma alemana, el hecho de simplemente exportar tus productos a otro mercado dentro de Europa, ¿no? En este caso el alemán, tal y como se ha planteado la ley alemana, a diferencia, por ejemplo, de la holandesa, que sí que se aplicaría, la de protección de trabajo infantil, la de prohibición de trabajo infantil, que ya está vigente. Tú no tienes por qué tener una empresa en Alemania, simplemente como si vendes tu producto o servicio en mercado holandés ya estás obligado por la ley holandesa de prohibición de trabajo infantil, ¿no? Aquí en este caso parece que con la ley alemana, por el puro hecho de vender tu producto o servicio en ese mercado, no. No obstante, vuelvo a decirlo, yo creo que todas estas leyes que poco a poco se van publicando en nuestro entorno, de una manera directa o indirecta, van a acabar afectando y finalmente también es una cuestión de competitividad, ¿no? Si tengo empresas en mi mismo sector que están cumpliendo estos estándares, probablemente tengo que recumplirlos también, ¿no? Para estar en igualdad de condiciones. Que de ahí viene un poco el sentido de la petición incluso del sector empresarial de que esto al final acabe siendo regulado por Europa, ¿no? Para armonizar y tener unas condiciones similares en todo el mercado europeo.
Sí, y como dijeron los compañeros alemanes, ¿no? Al final hay un efecto rebote, que al final el proveedor español al final no está directamente obligado, pero alemán sí está obligado a vigilar el proveedor español. Por lo tanto, al final la presión será comercial y será, si quieren seguir haciendo negocios con Alemania, pues sufrirán.
Siempre que tu producto lo vendas a una empresa que esté obligado por la ley española, y si eres proveedor directo o incluso si eres indirecto, vas a tener un efecto de esta ley, ¿no? Que te va a obligar a revisar tu propia debida diligencia en temas de derechos humanos y medio ambiente. Sí.
Very good. So I mean, there are still open questions. Unfortunately, we cannot, let's say, answer them all, because otherwise we would still be here 1 more hour. And as we have German guests, we don't want to be too impunctual. So let's end it here. Thank you so much, Mark and Eric, for joining and sharing your views and shedding light on this really interesting German regulation. Y muchas gracias a todos por asistir. Cualquier pregunta que tengáis al respecto, pues aquí tenéis nuestros contactos y encantado de comentar con vosotros. Muchas gracias. Vielen Dank.